Willem, on Miss Castillo, other than saying that you all are opposed, is there anything else to put on the record?
Just the nature of the charge.
Okay. All right, Miss Castillo, can you come forward, please? Good morning.
Good morning.
So my understanding from probation is that you've completed everything.
Yes, ma'am.
All right, so the state is opposed.
Yes, sir.
All right. We're going to go on the record in 2018 CR 6683, State versus Genevieve Castillo for the state.
We'll get through it too.
And are you Miss Castillo?
Yes, ma'am.
All right, so state, my understanding, you're opposed to early term?
Yes, Your Honor, the nature of the charge, this manslaughter, this defendant accidentally shot a man in the head. He took a trial, was found guilty, and I believe that 10 years of probation is frankly a gift.
All right.
Based on that charge.
All right, thank you. You may be excused. Are you Officer Wolf?
Yes, ma'am.
Raise your right hand for me, please. You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. Can you tell me what is your relationship to this case?
I am the supervising officer for Miss Gina Castillo.
All right. Have she completed everything that was asked of her and all of her conditions?
Yes, she has.
All right. Do you recommend early termination?
Yes, I do, Judge.
All right. Thank you. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Genevieve Castillo.
All right. What have you learned?
I've learned that it was a very young age, this accidental incident occurred. I have two small children now, 11 and 5, and my daughter starting school now. I work 2 jobs to provide for them. I completed cosmetology school, and I went into school for business and management, but I put a stop to, well, not a stop, but a hold on it to provide for my children. And I've learned that, don't take life for granted.
Yeah. And I can tell you, I'm the judge that presided over this jury trial.
Yes, ma'am.
So I do remember all of the facts of it. And basically, you were a young child. I say child, but legally an adult.
Yes, ma'am.
The person who died was young,
Yes, ma'am.
a young child, though legally an adult. And both of you all were playing with guns.
Yes, ma'am.
And so it wasn't something that was done intentionally. So the court will grant your application for early term.
Thank you so much.
All right, you're welcome. Just check in with probation and they'll give you what you need to have, all right? And thank you, Officer Wolf. For
Yes,
coming.
ma'am. Thank you.
Good morning. So did you all get the ruling?
Yes, Your Honor.
All right, so there's something I'm supposed to put on the record, so I'm just waiting for them to pull everything for
Get you
me.
some paperwork.
You want the client to come up, Judge?
Oh, just 1 second, let me read this and then.
Jonathan Manuela Estera.
All right, so they're asking that and another judge heard this. I didn't hear the motion to suppress, but the judge who heard the motion to suppress granted it. And then the Fourth Court of Appeals affirmed, and then it was appealed and I think this is a Court of Criminal Appeals. They reversed.
Correct.
All right, so we just need to place that on the record. And then once it's placed on the record, then we'll see where we go from here.
Oh, okay.
There's a little bit more appellate history, Judge. I didn't know if you.
Oh, no, I didn't.
Okay. After the Court of Criminal Appeals reversed, it got remanded back to the Fourth Court for clarification.
Yes.
Then they ruled, essentially kind of it clarified, I guess, more in the state's favor, really. And then that's where, Mr. Cavazos and Mr. Rodriguez can fill in the next step after that.
Okay. All right, so is there more than what I have here? Because they
Yeah,
just say it's
a
reversed.
petition for discretionary review was also filed by Angela Moore on behalf of Mr. Rodriguez, that's appellate counsel. And that
So-
was,
the petition for discretionary review, that hasn't been filed recently, right?
It was filed and it was reviewed by the Court of Criminal Appeals and they rejected it.
They denied that, and now there's a.
And now there's a writ that Stephanie Boyd will be filing on behalf of Mr. Rodriguez.
No, not me. I'm like, I'm following the writ.
That could be a conflict, right?
So what writ is being filed?
I believe it's a writ of habeas that's going to be filed with the Supreme Court.
Okay. And when is that going to be done?
Mr. Rodriguez is here today. He's already paid Ms. Moore for her services. And my understanding is that she's anticipating filing that within the next 30 days.
All right. Could I have do either of you have the opinion from the fourth court?
I don't have it physically, but I can email it to you, clerk.
Oh, yes. Let me give you my email address because I want to make sure everything is placed on the record as it should be.
You're talking about the opinion on the discretionary review?
No.
No?
Because you all are saying the motion to suppress that was reversed, there's something specific in it?
Right, yeah, after it went down to the Court of Criminal Appeals, when they reversed, they remanded it to the fourth court for clarification on an issue that they felt like they didn't need to address, or to address that in an opinion. Then Mr. Rodriguez filed a petition for review of Court of Criminal Appeals based upon that decision, which was denied, and now they're doing their petition / writ for SCOTUS. We need a charge, Judge.
Well, it's been reversed. So we will go on the record.
And Judge, this is the Court of Criminal Appeals one. There's the subsequent one that was really added to the court.
Oh, can I
Yeah.
have that one?
Kind of like down here, like.
Yes.
Remand to the.
Yes. Could I have the second one then?
Let's see if I've got that.
Well, and Judge, I will agree too. It says remand the case of the trial court for further proceedings. Then that's when they did the
Get that
petition.
thing.
And then, so it wasn't, I misspoke. The fourth court, Court of Criminal Appeals didn't remand it to the fourth court. It was because of the petition. Again, like I said, I need a chart.
Yes.
No, especially when you do the petitions for discretionary review, then it like throws everything off.
True.
Oh, it seems that they didn't, from what I'm reading from this, the defense filed a supplemental brief stating that the manner and scope of the warrant was exceeded.
Mhm.
But it appears from reading this, let me see if they responded to that. All right, so in this, they're saying that the search did not exceed the scope because there was no scope.
Because they were relying on a consent form that was signed.
Yes.
Sorry. A consent form that was signed after he was presented with a warrant and before he was questioned at the
All
station.
right. So Eric Rodriguez. Okay, and the motion to suppress, I guess it was only filed under 2021 CR 0735.
It was filed under 2021 CR 0699 as well.
All right, because I see 6. Okay. All right, we're gonna go on the record. Everyone, please whisper. Court is calling 2021 CR 0699 and 2021 CR 0735, State versus Eric Rodriguez. Could I have parties announced for the record?
Stephen Spear for the state.
Jaime Cavazos for Mr. Rodriguez.
And are you Mr. Rodriguez?
Yes, sir.
So in reading the opinion from the Fourth Court of Appeals, the appellate cause number is 04-22-00727-CR. and 04-22-00728-CR. Is that correct?
That is what I have as well. Yes, Your Honor.
That's what I have.
But in the body of the opinion, it states that it's trial court cause number 2021 CR 0735. It does not mention the other cause number, but I'm making the assumption, since there are two CR numbers, those are related to two different trial court cases. Is that correct?
Two different charges, yes.
Okay.
That is my understanding. Yes, Judge.
All right. So my understanding that a ruling was made on a motion to suppress in the 226th District Court. And it was a motion to suppress data from a cell phone. That motion was granted. Then it was appealed. The Fourth Court of Appeals ruled in the defense's favor. And then the state filed a petition
That
for discretionary review. And the ruling on the petition for discretionary review was to reverse and remand to the Fourth Court. Then the defense wanted to file a supplemental brief stating that the scope exceeded the search warrant. And so the Fourth Court of Appeals ruled on whether or not the scope was exceeded. And the Fourth Court of Appeals stated that the scope was not exceeded. And the Court of Criminal Appeals ruled that the motion to suppress should have been denied. Is that correct?
Correct.
So the motion to suppress will be denied on the grounds that have been previously requested through the defense's appellate brief. All right, is there anything else with regards to the record on the motion to suppress?
The only thing that the record needs to reflect is that Mr. Rodriguez has hired appellate counsel, Angela Moore, and she is drafting a writ of habeas that will be filed on this case, addressing the opinion of the Court of Criminal Appeals and the affirmation by the Fourth Court.
All right, and when will that be filed?
My understanding from Mr. Rodriguez, Ms. Moore has been paid in full. She anticipates filing the brief in approximately 30 days.
And this is to the U.S. Supreme Court?
I believe so, yes.
All right. Ms. Ferguson, recall this case in 45 days. And I need an acknowledgement of discovery if one has not been completed before you all leave today.
I can do that, Judge. Yes.
Thank you.
The 21st
Oh.
of September.
All right, so we're going to be back on September 21st. Is there anything else that you all are requesting to be placed on the record?
No, Your Honor.
Not at this time.
All right, so that's going to be a status hearing. We're going to see what's happening at the appellate level, okay?
Very good. Thank
All
you,
right,
Judge.
Thank you, Judge.
Thank you for dressing appropriate for court. Once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring the reset form to you.
Yes, ma'am. Thank you.
You're welcome. Lee Martin Saldana. If you come down, please, sir. Hello. All right, your attorney is currently in jury trial in another court, so we're gonna recall you, okay? All right, Norma, recall this for August 18th.
Yes, ma'am.
If your attorney is finished sooner, he'll let us know and we'll have you brought back sooner.
Yes, ma'am.
Do you have any questions?
No, ma'am.
All right, thank you. All right, Deputy Laura, can you bring out Adam Gonzalez?
Standards and the deaths that be occurring there. So the average, we're trying to put our heads together, it's, to come up with some creative solutions, diversionary measures.
Yeah. All right, on this case, where are we on discovery?
So Judge, I spoke and conferred with the state. It appears that there is perhaps missing a dash cam video that shows the alleged reason for the traffic infraction. So we believe that's out there. This is a first discovery hearing since indictment. So I know Lauren went ahead and emailed the law enforcement agency to see if they have any additional videos, because we believe that those are outstanding.
All right, Norma, if I could have a 30-day reset for discovery.
Yes.
Your Honor, maybe we do August 25th, Tuesday, if that's okay.
Is August 25th okay?
Yes, ma'am.
No, I mean for them, but is it okay for you as well?
Perfectly fine.
25th? Yes.
Yes, awesome.
Do you work?
Yes, ma'am.
All right, you can zoom in if you want to zoom in.
That's fine.
All right, thank you.
Okay, then.
God bless you.
Thank you, Your Honor.
God bless you too.
I appreciate that. Thank
You're
you.
welcome. Charlie Marquez.
Yes, Your Honor. No, sorry, you're not my honor. You're not the honor. She's the honor.
I was thinking the certain field.
Yeah, I don't think we're handling it today. We're getting close.
All right, what is happening with this case?
Judge, I think we're still confirming, we can get a little more time to come to an agreement. At least come to a understanding.
Well, do you have all the discovery on the number one?
That's the reason why I said it was a reset, Your Honor. We're still missing some paper discovery in the new
All right,
case.
what discovery is missing?
Everything, Judge. I think you'll have lab discovery, you'll have lab.
Yeah, we're missing those things. And
Lab work.
there's a couple of supplemental reports because it was a surveillance type of stop, Your Honor.
All right.
And it's from June. So it's a newer case.
Norma,
Yes, ma'am.
set this for a contested hearing in 30 days. And if it's not contested, it's not contested. And if it's not going to be contested, you need to let probation know that it's not contested, but otherwise it's going to be contested.
It will likely not be, Your Honor, but we will communicate with probation.
September 3rd.
All right, September 3rd, y'all need to have witnesses available.
Thank you.
Thank you, Judge.
Thank you. Jose Guevara. Hello, why were you late?
We got that at 30 and then we got here, there's a long night. We're gonna leave at 8.
All right, so here's the thing, you can't be late for court. If another judge were sitting here, you know what would happen? You'd be in custody. Or either they'd ask for a drug test today. And I don't think you want a drug test today. So let me tell you something. If you continue on the path that you're on, only one or two things gonna end up happening. Either you're gonna be in jail or either somebody's gonna be identifying your body. So when you leave here, you need to go to a sober support meeting. Do you understand? Okay. And so he keeps using, that's an issue.
Yes, Judge, we had a lengthy without getting into it, with a lengthy conversation about that. I know the court has ordered him into a program. He set up for a Zoom meeting. His mother is here in the courtroom as well. I also suggested sober support meetings, so I think that's at least a step in the right direction. And we talked about inpatient, but he has limited
So
resources.
what's happening with this case?
Judge Knox has been tended to the defense, I believe all discovery.
Well, this was set for jury trial in June. So this is coming back next week for jury trial. So, and are you all reaching an agreement today? Because if you're not reaching an agreement today, jury trial is going to be on August 10th and it's going.
We don't have an agreement right now, Judge.
All right, so plea deadline date has expired. The court will not accept any plea bargain agreements without good cause. So this is coming back to trial on August 10th.
Thank you.
You on the top row at the end.
All right, once you sign the reset form, you are excused. Hello,
Sorry.
that's okay. All right, who's the state on this? Court is calling 2025 CR 0069333. State versus Valerie Marino. Do you have a copy of the motion to revoke? Could I have parties announced?
Brandon Credit for the state.
Travis Kettner, Your Honor, for Valerie Moreno, we're ready.
And are you Valerie Marino?
Yes, ma'am.
Is it just me or is it hot in here today?
It's always hot.
I'm like, whoa. All right, the defense has filed a motion asking that a bond be set. A motion to revoke was filed and it's a deferred adjudication. So have you all had a chance to confer on the allegations in the motion?
Not to my memory, Judge, but we can confirm.
Yeah, Judge, I mean, we did talk about it a little bit yesterday, Judge. It's an issue. She got in an argument with her ex-boyfriend and she had his car towed.
Mhm.
The car has been recovered. It was recovered the next day, but that's the item that she was accused of stealing.
All right, so we're off the record. So she's accused of stealing an item that she had towed
I think it was an authorized use of a motor vehicle, Judge. Could I have a
because
few
it was
minutes
towed? Yes, if y'all would step back.
Okay.
Is there, you're Adam Gonzalez? Come down, please. Hello.
Good morning, Your
Good
Honor.
morning. Your attorney is in a jury trial, so they can't be here. So we're gonna call you back in 2 weeks. Norma, I need a 2-week reset on Adam Gonzalez.
August 18th.
All right, do you have a question about anything?
I don't know.
All right, we'll see you back on August 18th. All right, and you're ready with the interpreter?
Yes, sir.
All right, if he'll come down, what's your client's name? Okay, let me just find him on the docket. All right, so on this case, there was missing just 1 second. People in the box, you're not allowed to speak to each other because that puts the deputies on high alert. The only advice that you can really get from somebody in jail are 2 things. One, what's the parole like? Are people paroling at a faster rate? And 2, when are you going to catch chain? Anything else, you need to speak to your attorney because guess what? They're in the same boat you're in. All right. Hi.
Hi.
All right. So on this case, we were here for discovery. Therapy was missing, some hospital records. So where are we on that?
I don't know that we received the hospital records yet. They were gonna subpoena them. It might be, there might not be any. I'm not sure what the status is.
And are there any CPS records?
No.
Okay.
It's an adult case.
Okay.
For the record, Your Honor, the hospital records have not been. Apparently, method assessments, the physician who has sent certified. So that the person can know they haven't sent us back.
So has it been sent certified mail?
We have sent our reports.
And when was that sent?
Or a month ago, July. And then as far as the counseling, we're fine. Looks like they're having a lot of trouble with it. No one's answering this phone to confirm how we can go about getting into them. We even made an attempt to go to the place in person and the door was locked. Nobody answered, phone calls from there. 3 voicemails were left and still, call back as we received.
Sounds like somebody's gonna have to do a stakeout.
Therapy,
Yes, I would suggest Tuesday. No, I'm serious,
Tuesday.
based upon my experience.
So I'm just not 100% confident as of right now in the situation for therapy, but the hospital like forcing them to send.
Do you know who's the therapist? Do you know who that is?
The place called Life Path Counseling on Blanco Road.
All right, Norma, on this case, recall it for 30 days for discovery.
Yes, sir. September 3rd.
All right, so we'll be back on September 3rd. Do you have any questions?
No, thank you, Judge.
Oh, do you have any questions?
No,
All right, thank you.
thank you, Judge. Continue.
Yeah. Do you need me to sign anything?
Not today. Thank you, Judge.
All right, thank you. And Norma, could you make sure
Thank you very
that
much.
this is down as a hearing?
Toma asiento, por favor. As a discovery.
Yes,
And you said September 3rd, Judge?
yeah, September 3rd, and that's for the interpreter as well, Norma.
Yeah.
Lawrence Tucker. How are you doing?
Good morning, man.
Good morning. So they're saying they're not going to accept you into Veterans Treatment Court. I don't understand that.
I look at it, maybe I'm just not as bad off as some of the other ones are already
No,
having to work with me. I don't know.
no, that's not it. They have their issues. with who they accept.
That's what I told him. I said, y'all are veterans, but y'all pick and choose who y'all accept instead of accepting all veterans.
Mhm. So we're gonna take care of this.
Yes, ma'am. Thank you.
Sure. Who's the prosecutor on Lawrence Tucker? It's on page 2. No. All right, just have a seat. We're gonna see what we can do, okay?
Yes, ma'am.
All right, thank you.
Judge, we did get the police reports.
Okay, all right, thank you. So y'all let me know what y'all, Valerie, what's happening with her?
I think we're still at the same place as regards the bond.
Yeah, I believe
Well, I mean, the-
Yes.
The MTR, is it as he says that she had his vehicle towed?
Judge, if I may, for the vehicle was towed, however, there's a little more to the story. Apparently, a complaining witness bought the vehicle. Ms. Moreno, sorry, Valerie had access to the vehicle. She sold the vehicle without his knowledge. There's text messages that are confirming this, and the vehicle was recovered stolen 2 days later.
So her, obviously, I mean, that's argument for another time, right?
Yeah,
You know,
no,
but
and I just,
Yeah.
you know, if it's something that can be solved today, then let's solve it today.
that would be nice. I don't know if it could be solved today, but she would like to get rid of the evidence and then we can maybe talk more about the theft allegation. But he did get, the complaining witness did get his car back. So
That is correct.
it's not quite, the prosecutor said it's maybe not quite no harm, no foul, but he did get the car back.
So what are y'all, on the motion to revoke, what is
Oh.
everybody gonna be asking for? Revocation? What are we doing?
Judge, I haven't seen them.
Yeah.
Oh,
She-
this is
yeah.
the only thing that's in the motion to revoke is this theft case.
Can we have a moment to confer, Judge?
Sure,
And we can do
sure.
that.
All right, thank you. Here's a, yeah, sure.
Thank you so much. Thank you
Yes.
for putting with her.
Judge, we have spoken. There is one kind of middle piece of this, right? So we understand she had the car towed. What we don't, what neither I nor the state know is exactly what happened with the car in between the time it was towed and when it was recovered. I know it's gonna be set for an MTR and what I told him is.
Does anybody want to call the complainant and ask what
I
happened?
have
with it?
tried, or not the complainant. The complainant, I think, is the person that probably knows less than the tow truck driver.
Okay,
But what I was gonna say is if we could handle the warrant and then come back in 2 weeks on the motion to revoke, I think that would move both of these cases very quickly. Just probably not today.
And the state's in agreement, Judge.
okay, just give me one moment.
Of course.
I mean, there's only one thing we don't know.
What do y'all not know?
Oh, whether or not it was truly sold or not, which there you have the issue, the legal definition of theft, and then kind of the practical issue of who was damaged and how much.
Okay,
But it's not particular, it's another state jail thing. It's not.
okay, just give me one moment. All right, Ms. Marino, if you'll come down, please. Court is calling 2025 CR 006-933, State versus Valerie Marino. Can I have parties announced for the record for the state?
Brandon, ready for the state?
Travis Ketton, Your Honor, for Valerie Moreno, we're ready.
And are you Valerie Marino? All right, we're here on a motion to enter adjudication of guilt and revoke community supervision. Defense is asking for a bond.
Just for correction, Judge, it's, yes, I'm sorry, yes. I apologize, just for the bond. I heard the first part, I was like, no. So yes, it's just for the bond, yes, ma'am,
I'm just making the record clear
yes.
what you're seeking a bond on. All right. So do you all have an agreement to a bond amount?
Judge, the agreed bond amount is $8,000.
If that's correct, Judge, my client has already made arrangements and paid the bail bondsman for that bond, and so when she found out about the warrant, I organized this so she could come in and turn herself in.
What's the criminal history?
The only other charge she has, Judge, is this case or the prior case that she was on probation for, which is a state jail criminal mischief. In that case, she has not, other than this problem, she has not had any problems on probation. She has already paid all of her restitution. So she's obviously an extremely responsible young woman, and we just wanted to take care of this. We do have a question, and like I said, we'd be happy to come back in approximately 2 weeks to deal with the motion to revoke. We just need one more piece of information.
All right, so here's my question, and I need to know this answer in order to set an appropriate bond amount. The new number one, I'm not holding either of you to these facts, but the theft of the property, who is the alleged complainant?
Her ex-boyfriend and the
All right.
father of one of her children.
All right, and the theft of the property, we had already spoke off the record that it's involving a vehicle that may have been purchased by the complainant.
Yes, ma'am.
And then the defendant is alleged to have had the vehicle towed.
That's the alleged facts, Judge.
All right,
The complaining witness has recovered the vehicle, or the police recovered the vehicle. I'm assuming the complaining witness has recovered the vehicle. And we just have that missing middle part that we will dispute at a soon to be agreed upon date.
all right. The court is gonna set the bond at $1,500. And this is gonna be recalled in 2 weeks for disposition. Ms. Ferguson, I need a 2-week reset.
August 18th.
Okay, August 18th. Is there a lot already set on August 18th? All right, August 19th.
Judge, would it be possible, I don't know the court's procedure, would it be possible for her to go to the satellite office? She does have the paper bond
Here's
with
the
her.
thing, you'll need to speak with
Oh,
the
okay.
deputies concerning
Oh.
that. All right, so we'll be back on August 19th.
All right, thank you very much.
Thank you.
Judge.
Mr. Tucker, if you can come forward. Do you have good contact with your attorney?
Yes.
All right, so what we're gonna do, Ms. Abrams, we're gonna recall Mr. Tucker in like 20 days, and it's gonna be a PTD, so. Ms. Ferguson, on Tucker, can you recall that in 20 days? And it's gonna be a PTD.
August 24th.
All right, August 24th. With your attorney and let them know that the state has extended an offer of a PTD, okay?
I'll email the session.
All right, thank you.
We're gonna ask what a PTD is.
No. Your attorney will take care of that. And the state just said they'll email your attorney. So just sign the reset form and we'll have you back on August 24th, okay?
Good.
All right,
Thank you, ma'am.
you're
Have an
welcome.
outstanding day.
You too. Brandon Pettis. All right.
Mr. Bettis, has been a client for a decent amount of time, Your Honor,
Mhm.
but I just got hired on these, new cases. So we'd just like a reset just to be able to, have them do some courses and, get some witness statements, with our investigator and then turn those over to the state.
So are you on all of his cases?
There was an issue that we weren't filed in on one, so we'll be filing in on the other case this
All right,
morning.
and that's the 49 cause number.
Yes, Your Honor.
All right, Norma, recall this for 30 days for discovery.
September 3rd.
All right, once you sign the reset form, you'll be excused.
Okay.
All right,
Thank
just
you,
have a
guys.
seat, your attorney will bring the form to you. Have a good one.
You too, thank you.
You're welcome. Yvette Alacon. It's like I just saw you a few minutes ago. So on this case, where are we on discovery?
But we have all the discovery, Your Honor.
Yes. Was an offer tendered?
No, not yet. We're still in the preliminary stages of negotiations, Judge. My clients completed several courses, parenting courses and a couple of other courses. Those have all been filed into the case.
Mhm.
And we'll be conferring with the state via email and phone conferences over the next couple of weeks.
All right, Norma, recall this for September 3rd. State at that time you need to be prepared to tender an offer.
Yes, ma'am.
Thank you, Judge.
Thank you. Once you sign the reset form, you will be excused.
Thank you.
Good seeing you, Judge.
You too.
I did.
Court is calling 2026 CR 008-810 and 2025 CR 008-697 State versus Isaiah Gonzalez. Can I have parties announced for the record?
Andrew, finish the state.
Amanda Hernandez for Mr. Isaiah Gonzalez.
And are you Mr. Gonzalez? All right, probation, there are no applications. State in each cause, I'm sorry, defense in each cause number, have you received all discovery and reviewed it with your client?
I have, Judge.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Gonzalez, have you reviewed the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? I'm sorry, in each cause number? Mr. Gonzalez, in each cause number, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
And the cause number ending in 9-4, you're charged with assault family household with a previous conviction. And the cause number ending in 10, you're charged with evading arrest, detention with a vehicle. Both of those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to your plea bargain agreement, the cases will run concurrently. They also will run concurrently with Colorado County cause number 24-088, Kendall County cause number 25-535CR, 25-536CR, 25-704CR. And in the cause number ending in 10, there's a $700 fine. That fine is not to be probated, correct?
On the Daisy, yes.
Is he going to, there are no applications though, correct? So in the cause number ending in 10, the parties have agreed to a $0 fine, is that correct? And in the cause number ending in 9-4, there's a $1,500 fine. There's an affirmative finding of family violence. And there's to be no contact. There's to be no contact with the complainant. State on this case number.
That is correct, Your Honor. The defendant and I are both aware of who the John Doe is, but I believe you don't want me to state his name on the record. Is that correct? Yes.
All right. And there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition, and you're not allowed to be designated as primary custodial parent. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea in both of these cause numbers?
Yes, ma'am.
Defense and state, is that the plea?
Yes, sir. Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offer states exhibit 1 and all attachments under both clauses.
No objections.
All right. And in state, in the family violence case, have you spoken with the complainant?
Yes, we have, Your Honor.
All right, thank you. State, you may be excused. And each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And cause number 2026 CR 008810, the court will find there sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing in that cause number?
Yes, Your Honor.
Anything you wish to say on behalf of your clients?
Only, Your Honor, that there were some mental health concerns addressed with the state prior to this plea, and I will kind of leave it as vague as that unless Your Honor would like to hear more.
Thank you. All right, and that cause number, the court is finding you guilty. Court will sentence you to 5 years in prison. Give you credit for any time served. Court will recommend the therapeutic community for mental health. There's a $0 fine. This will run concurrent with 2026 CR 008394. Colorado County case 24-088. Kendall County cases 2025-535 CR, 2025-536 CR. Twenty 2025-704 CR. And there's to be no unsupervised contact with minors. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
Okay. All right. Mr. Gonzalez, you're under oath. The person who's listed as John Doe in the indictment is the same John Doe that's listed in these stipulations?
Yes, ma'am.
All right, then in cause number. All right, then in cause number 2026 CR 008934.
It's 8394, Your Honor.
Oh, I didn't say 8394, I'm sorry. So in cause number 2026 CR 008394, court will find you guilty. Court will sentence you to 5 years in prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrently. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no residing in households with minors. No unsupervised contact with minors. There's an affirmative finding of family violence. This will run concurrent with the following cause numbers: 2026 CR 008810. Colorado County cause number 24-088. Kendall County cause numbers 25-535 CR. 25-536 CR and 25-704 CR. Court will recommend the therapeutic community for mental health. All right, and that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
That's right.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
With regards to the therapeutic community, I do not have the legal authority to order them to place you in the program. So if you want to be in the program, you are going to have to request it as well, but they'll see on the judgment where I place that, okay? All right, good luck to you, all right?
Yes, ma'am. Thank you.
You're welcome.
Maybe
Counsel, yes. Darlene Gonzalez. Morning. Are y'all proceeding on the motion?
No, I'm asking for a little time. She's got two new number ones that I'm appointed on one. I just appointed about a week ago, and they are involved in the proposed plea agreement. I need to review the evidence in them. So I'd like a short recess so I could review the evidence in those.
All right, how much time are you asking for?
3 weeks.
All right, Norma.
Yes, ma'am.
Can you recall this the week of the 18th? Is that good for you? Or
Yeah.
the 17th?
Yeah.
Yes. All right, August 19th.
Okay, thank you.
Lily Herrera. Court is calling 2025 CR 006045 State versus Lily Herrera. Can I have the parties announced?
Brandon Ferreira for the state.
Alfonso Otero on behalf of Ms. Herrera.
And are you Miss Herrera? Yes. All right, Miss Herrera, you were previously appointed a different attorney. That attorney is unable to appear. Do you have any objections to this attorney being appointed to represent you?
No.
All right, and counsel, do you waive notice?
Yes, Judge.
Ms. Herrera, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand that? Are you the same Lily Herrera who's placed on deferred adjudication in 2025 CR 006045 for the offense of possession of a controlled substance, penalty group 2, 1 to 4 grams, on February 19th, 2026 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Judge will be proceeding on violation condition number 2, specifically the on or about the 26th day of March, 2026.
Excuse me, I don't have a violation of condition number 2. Is there a supplemental?
There should be, Judge.
Hold a minute.
Okay, thank you.
One that the VA themselves actually.
Did you review the supplemental motion on the deferred adjudication?
The paperwork.
Yes. All right, state, you may proceed.
Judge will be proceeding on that violation alone. I'm be waiving all the other violations.
Any objections to the waivers?
No, Judge.
And counsel, if you read violation of condition number 2?
Yes, Judge. Oh, sorry.
Of course, Judge, my fault. The violation condition number 2, specifically on or about the 26th day of March, 2026 in Berry County, Texas, the defendant, Lily Herrera, did then there consume an alcoholic beverage in violation of condition number 2.
How do you plead to that, true or not true? Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge. Proposed agreement is to amend conditions for intensive outpatients.
All right, and what's happening with the other the other violations in the other county?
Those other violations are out of the county. We're basically leaving them where they lie.
All right, so does she have a bond for those other cases? Does anyone know?
That's for our knowledge, Judge.
Do you have a bond for those other cases?
Right now, I don't know. They said that they're gonna wait for indictment or something like that.
All right, so if they're saying indict, then,
I'm not sure about a bond. I think I do.
okay.
I think what I talked to the defendant is that they're waiting for labs on the two cases.
Because I don't want you to be held in limbo, okay? Probation, is this your recommendation?
Yes.
All right, then the court will find violation of condition number 2 true. Deny the motion. And alter and amend conditions to include intensive outpatient treatment with probation and weekly sober support meetings. Probation, is there anything else? Is there anything else you need from the court to be successful?
No, ma'am.
All right, so here's the thing. You are going to need to find out what you need to do to maintain your sobriety. Because while you're on probation, you're not allowed to drink any alcohol. Do you understand? All right, if you need something, let probation know, all right? All right, good luck to you.
Thank you.
You're welcome.
Thanks, Judge. Maybe excuse.
Yes. Jeremy Cruz.
Cruz?
Hello. It's like I'm gonna see you again
Lucky.
later
Lucky,
this afternoon.
lucky are we.
I was telling them I had such a great salad yesterday, and it was because they chopped it.
We chop all ours.
Yes. All right. So where are we on this case?
You're going to be last time, Judge, on him.
Yes.
Look at that tab. There's a couple. I thought I would be ready for this one. I've read all of this. I just haven't shown any videos, but I think.
Oh, everyone, please whisper.
I believe there's going to be a resolution to this case. I don't think I'm going to be a trial. I just need a little time.
All right, Norma, set this for disposition at the end of August.
Yes.
All right, so we'll be back on August 31st. Do you have any questions? I have a question. Did that neck tattoo hurt, especially on this? And you still was like, hey, I'm in it now. I can't leave it half done.
Too deep.
All right, thank you.
Thank you, Ms. Boyd.
Have a good one.
Good day.
All right, Fonseca. All right, so in this case, where are we on discovery?
We have discovery on one case. The other, he's got 2 other cases in pre-file that are coming down, awaiting indictment. And I talked to the state. They're gonna reach out to intake to see if they're gonna proceed with those and give us a global offer if they do that.
What are the 2 cases that are in intake?
One is theft from a person, the other one is collision involving injury. And from reading the reports and the notes, they were pretty serious.
Okay. Norma, recall this in 45 days for discovery.
Yes, ma'am.
All right, thanks, Steve.
Thanks.
September 20th.
All right, we'll see you back on the 21st. Once you sign the reset form, you're excused, just have a seat. And your attorney will bring the reset form to you. Thank you.
Thanks, Judge. Maybe excuse.
Yes, thank you. All right, who's here on Robert Peave House? And is this an application, counsel?
Call an application, Judge, request yes, I am.
All right, I need a PSI date.
I know that your calendar's full, Judge, but he's been in custody since May of 16.
I can do September 15th. Right on time, Michelle, that's 6 weeks.
So here's my question. So we can call it back on that date, but if you just want to call it back on a different date and have witnesses, because you're playing open, so state, what are you going to be asking for? All right, and you're going to be asking for probation?
Yes, Your Honor.
So if you want to call it back in a week or a couple of weeks, and I can hear whatever evidence you want to put on, we can do that. Otherwise, the PSI takes the time that the PSI takes.
About 2 weeks, Judge.
All right, so you're
But
going
I
to
have a
wait.
full calendar next week as
Okay.
well. So.
All right, Norma, can you recall this in 2 weeks?
They're August 19th.
All right, August 19th. What I can tell you is I'm not going to be here on August 19th, so it will be a different judge hearing it.
You're doing for it because she's not going to be around.
You're not gonna be on the 19th, Judge?
I can tell you who the judge is, and you can. So if you want, we can
Okay.
call it for a different date, or we can keep it for that judge.
He's willing to go with Judge Herger.
Okay, all right, so then Norma, this is gonna be called on August 19th.
Yes, ma'am.
All right, the court is calling 2026 CR 0075558 State versus Robert House. Could I have parties announced?
Rick Pena for the state of Texas.
Jerry Valdez Jr. from Mr. Peahouse.
And are you Mr. House?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
Court will find the state is in compliance with discovery. Mr. House, did you review the application with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
We do, Your Honor.
State proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. House, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with failure to register as a first-degree felony. The range of punishment is 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, he is and he was.
Mr. House, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promise you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
So according to your plea, you're going open to the court on punishment to be assessed. So what does that mean? That means that there really is no cap to what the court can sentence you to if the court were to decide to sentence you to prison time. So that means that the court could grant your application for community supervision, or the court could sentence you anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Do you understand? So you understand that's what going open means to the court. Do you understand?
Yes, ma'am.
Now, the state, they are going to oppose your application. Do you understand that?
Yes, ma'am.
And of course, you will have to register. So is there anything that you do not understand about the plea bargain agreement or lack thereof that you've reached?
No, ma'am.
The only thing that's been reached in your plea bargain agreement is the state is proceeding on count 1, that they're opposed to your application, and that you have to register. You understand? Everything else is open. Do you understand?
Yes, ma'am.
State defense is at the plea.
Yes, Your Honor, it is.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. This time, state will offer to evidence. This is exhibit 1 with all attachments.
No objections, Your Honor.
All right, state, you may be excused.
Yes.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. And with regards to count 1, do you plead true to the fact that you've been previously convicted in cause number CR-04-475 out of Hayes County, Texas on January 20th, 2005 in the 22nd Judicial District Court of Hayes County?
Yes, ma'am.
And that is true?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find the enhancement true based upon your plea of true, and the court will find there's sufficient evidence to find you guilty, and the court will find you guilty, and we will proceed with sentencing on August 19, 2026. All right, thank you. And PSI is waived.
And be excused.
Yes.
The seat, sir. Thank you.
Xander Vargas, court is calling 2026 CR 004029, State versus Xander Vargas. Could I have parties announced for the record?
Of course, Judge, Brandon Critter with the state.
Michael DeLeon for Mr. Vargas.
All right, and State, I see that you're working with other attorneys. You can make your announcements from the table if you wish to.
Thank you, Judge.
You're welcome. Counsel, you received all discovery. Did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Vargas, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it? All right.
Keep your voice so we can hear.
All right. Probation, this is an application. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
Excuse me, sir, you need to take a seat. Oh, that's okay. State, are you proceeding on the indictment as presented?
Yes, Judge.
All right, Mr. Vargas, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, you're charged with possession of a controlled substance, penalty group 2, 1 to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Vargas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, there's a $1,000 fine to be probated, and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes.
State defense, is that the plea?
It is, Your Honor.
Okay. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Any motions?
No motions, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 3 years, 100 hours community service restitution, a TAP evaluation, DOEP, and regular UAs. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Judge, I'll see to number 1 and 3 and all of that.
All right, state, you may be excused.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulation. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Judge, the particular law on this particular case is 3 vape pens, which are legally purchased at any
store in Texas. However, somehow they're illegal under Texas law. Otherwise, he has one DWI in his past, but otherwise no priors. He's been in custody for the past 30 days. We are asking that the PSI be waived and he be allowed to get out later tonight, even though there's a top evaluation. I don't believe I don't see any need for any immediate tap evaluation in custody.
Okay. How long have you been in custody?
Like 11 months.
All right.
I
How
think-
old are you? Listen, vaping, people think that vaping is healthier than smoking a cigarette. They're both bad for you. I've seen documentaries where people have what's called popcorn lungs, and I was like, what is a popcorn lung? You should look that up. You'll be shocked as to what you find. And I've seen so many documentaries where you have these young people who are vaping because they think it's cool. And they're in the hospital with popcorn lungs and they're trying to get a lung transplant. And suffice it to say, sometimes you're not at the top of the list. So how far did you go in school?
High school, diploma, got my diploma.
All right, so what are you doing with that other than vaping and jumping fences at military bases?
Just, I don't know.
Chilling?
You have a job right now?
Yeah, not as of right now, but I'm working my way.
All
to
right.
a job.
Working your way back, like the song. But what are you doing to work your way back? Are you just sitting at your house, vaping?
Flying.
Hmm?
Flying things, so if anything, trying to go back to school.
All right, you're trying to go back to school, but what have you been doing to get back to school? Because there are certain steps you need to take. You know? If you don't make the effort, then you're not really trying. You just have plans that never materialize because you really don't have a plan. I will say from a show I watched, you have concepts of plans, but you don't have an actual plan. So you got to start with a plan and follow through. Otherwise, you know what's going to end up happening? You are going to wake up and you're going to be 40 still with your concepts of plans, because your attorney will tell you, I will tell you, once you hit 21, the years just start flying by. And that's where you're at, where the years are going to be flying by. Do you live with your parents?
Yeah, just move on.
Your mom?
My IT sister.
All right. So in this court, I require that people have employment. Okay. Other than this vaping, any other drug use?
No.
Court is going to sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, proof of employment within 35 days of release. There's to be no employment as a home health care provider or with minors. There's going to be 300 hours of community service restitution. I will waive those hours if you obtain some sort of trade school certification or higher level education. And for that higher level education, that means you're a full-time student. None of this, yeah, I'm full-time because I'm taking 9 hours, but then you withdraw, 6 of those hours. So you're only doing 3. You understand? Yes or no?
Yes.
There's going to be field visits 1 time per month for 4 months. We'll do a TAP evaluation out of custody, follow recommendations. There's a $1,000 fine, and that will be probated. Probation, is there anything else? Is there anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Oh, add no possession of firearms. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
So let me ask this. How old are your sisters?
7 and 5.
7 and 5. And so it's just your mom, the sisters, and you, right? Is that correct?
Yes.
Let me just tell you something. Your sisters are going to seek their boyfriends, their spouses, based upon the males in their life and how they behave. So they're gonna base the person they select based upon what you've shown them what's correct. So you need to start doing things better. Your mom, I'm sure, doesn't have time to come pick you up from the jail, doesn't have time for all of this nonsense that you're putting her through. And you're gonna look back and regret putting your mom through this nonsense. Do you understand me?
Yeah.
So you had better start making better decisions. And I know what I'm saying to you now is going in one ear and out the other, but you may end up finding yourself in the movie, The Imitation of Life. You should watch that movie and maybe you'll appreciate your mom more. You understand?
Yes.
All right, good luck to you.
Thank you, Judge.
You're welcome. Who's next?
Rachel Acuna. She's on page 4 at the bottom.
All right. Hello.
Hi, Judge.
How's it going?
We're halfway through the movie.
Oh, hey. Okay. Hello. And you've already watched your movie. She said people would tease her about that all the time. All right, where are we on discovery?
I believe the state is, well, she's speaking.
Well, I believe that all the discoveries have been tendered to defense. The only thing we need to do is issue the expenditure on it, that like other not all shooters, well, there, so we don't do that. And then at the next sitting, I can be prepared to tender.
All right, so Norma, recall this in 30 days, and at that time, you'll need to prepare to tender an offer.
Thank you, Judge.
All right, what date?
September 3rd.
All right, September 3rd. Once you sign the reset form, you're excused.
Thank you, Your Honor.
Have a good one.
Yeah.
Jose Gonzalez.
I found it.
Hello,
I
how's it
did.
going?
Good, how are you today?
I cannot complain, although I still have cats in my head. The play, the
Oh,
song.
really? Oh, I love it. Did you go see it?
Well, I saw it years ago in
So
DC.
great.
And so all of a sudden it popped up and these songs are just in my head.
I love it.
Yeah.
That is, I love it. So I saw Rocky Horror Picture Show this weekend.
Oh, how was
And
it?
those songs are in my head. It was great.
Oh, yes. You know, it's
Huh? Time,
Yeah.
exactly. I'm ready to dance. I'm the classic. So.
all right. So on this one, there was missing discovery.
Yes, so I've conferred with Brandon and the state.
Mhm.
Both of us, I would say, need to educate ourselves a little more about Delta 9 and what obviously now it's all THC is the state of confusion in Texas.
Yes,
And
it
so we're trying to navigate it. So we do have an offer.
Okay.
At this point, we're not comfortable moving forward with that offer. I'd like to do some research
Okay.
and confer further with Brandon, see if we can get on the same page.
All right, Norma. On this case, I need a plea deadline date in 45 days.
That's perfect. I ordered some books, so.
Okay.
September 21st.
Perfect.
Well, you should just like Google, but I need to see it in the book. I love to read it.
I did just put it in ChatGPT, but I'm more confused now than ever. All right, perfect. Thank you, Judge. May we be excused?
Yes, and once you sign the reset form, you're excused. Thank you. Okay, now cats is out of my head, but now I have time warp there. Nicholas Morris.
Judge, may I approach on that?
Yes.
Judge, this is a case where he has a misdemeanor and a felony pending.
Yes.
We're in the misdemeanor court. I'm waiting for them to get a file. And so I anticipate all of it will be resolved and we won't need to approach you once it's resolved in the
So
misdemeanor.
you think it'll be resolved today?
Today.
All right, Norma, let's just recall this for tomorrow and then you can stop by later in the day if it's resolved.
Thank you, Judge. And I'm sorry for the delay.
You're welcome. Kevin Williams.
Oh, okay.
All right, today is plea deadline date and jury trial. So y'all have not reached an agreement?
No, we did reach an agreement that there is one piece of outstanding discovery, Your Honor. And subpoena was issued to Verizon. And they're gonna follow up. The problem with this case is that it's the people that worked on this case, the investigator, left. And now,
Well, that's not entirely.
Well,
The filing investigator is still with the fire marshal's office, assisting investigators.
He left.
CSO.
and I think they were assigned different parts of the file. I was just trying to explain that this didn't go like with one detective and that detective had everything. It just
So
kind
what's your
of
agreement?
piecemealed it.
There's not judges still trying.
All right. How long is this trial gonna last?
3 to 4 days.
All right, Norman, set this for the end of August for jury trial.
August 31st.
All right. Thank you. Once you sign the reset, is that good?
Well, so the forensic chemist, is it with ATF in Georgia, Judge, so she can either do the 3rd week in August, or, I'm sorry, 3rd week in September, or the week of the 24th in August, I think that's the 3rd.
All right, so which do y'all prefer, the 24th or September? Norma, does CDD have any capital murders or murder trials scheduled during that time?
The week of the 24th.
Yes, August 24th or the 3rd week in September.
There's nothing on the 24th or September, you said the 3rd week?
Yes, ma'am.
Let's see. I have on August 24th, it is a murder case in the 226. It's the co-defendant, and the main defendant has already been sentenced, had his trial, and this was a date picked months ago.
All right, is that actually going?
Yeah, Bridget Garza and I are trying.
All right.
Yeah.
So Norma set it for, how long is that trial gonna last?
Probably not more than 4 days, maybe 5.
All
I
right,
don't
it's set on
anticipate-
August 24th, right?
Yes, ma'am. Mhm.
All right, so then you say September when?
The 3rd week in September.
All right, Norma, what's down for the 3rd week in September? That's the week of the 21st.
I have the murder set already.
If the court would like, I can reach out to the scientist and see between the 24th and that 3rd week and see if she can accommodate or.
All right, so this is what we'll do then. You don't have to come back. You can appear by Zoom. Norma, when do you think you'll have an answer from your?
I emailed him right now, Judge, and he usually responds within a day or 2.
All right, so what we'll do is we'll come back on this case on Thursday to get a jury trial date. So recall it for the 6th, and you have contact with your client, I'm assuming. All right, so you don't have to appear in court on the 6th. Your attorney will give you your jury trial date.
Yes, sir.
All right, but if you want to appear, you can, but you don't have to.
And Your Honor, at that time, can I get a status on those records?
Sure.
Okay.
All right, thank you. Once you sign the reset form, you'll be excused. All right, thank you. Richard Bailey.
Good morning, Your Honor.
Good morning. For state jail felony, this packet is very thick. All right, the court is calling 2023 CR 6189, State versus Richard Bailey. Can I have an announcement from both parties for the state? Oh, you can continue to confer that from there. For the defense?
Scott Hill.
And are you Mr. Bailey? Counsel, you received all discovery. Did you review it with your client?
I have, and I have.
Court will find that the state is in compliance with discovery. Mr. Bailey, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, I did, Your Honor.
Counsel, do you waive the reading?
I do, Your Honor.
State proceeding as presented?
Lauren Espinosa for the state, no, Judge, we are waiving count 2 proceeding solely on count.
Any objection?
No objections.
Probation, no applications? Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Your Honor.
You're charged with theft of property, 2,500 to 30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If I do not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was, Judge.
Mr. Bailey, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Honor. Yes, I did, Your Honor.
According to the plea, punishment is to be assessed at 1 year in the Bexar County Jail under 1244. There's a $0 fine, no applications, and the state is proceeding on count 1 and waiving count 2. Did you understand that as your plea?
Yes, Your Honor.
State defense?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Any such motions?
No, Your Honor.
To count 1, how do you plead? Guilty, not guilty, or no contest?
No problem, Your Honor.
State any evidence?
Thank you, Your Honor. State offer states exhibit 1 and all attached.
No objection.
All right, state to me the excuse. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presented in the forms of police reports and statements, but most importantly, there'll be no live testimony? Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, actually, yes, I'd like to explain to the court that just a few weeks after this offense date, he was picked up on an unrelated charge and then subsequently sentenced to TDC. Where he was just released from TDC just a few months ago. So we'd like the court to grant him credit for the time that he served, because the warrant came out on this case back in late 2020.
All
He
right,
was,
what date was the warrant in this case?
the detainer, I don't have the warrant date, Judge, but the detainer that was sent, I have a copy of that. That was
Yes.
April of
July 23rd, 2023.
no, the detainer. Give that to me now, I can see it. The detainer, it was April 2021, Judge.
The warrant went out.
September 15th, 2020? All right. You see, the clerk is.
She's much faster than I am, yes.
I'm taking a little.
So Judge, we just asked you to give him credit for those days. He was a
Well, the
model.
warrant, let me ask you this. So the warrant for this case goes out on September 15th, 2020. When was he in custody for TDC?
He was in custody since May of 2020, but he finally made the trip over to TDC April 31st, 2021.
All right. It sounds to me he has the judgment satisfied.
Yes, Judge.
All right. Court is going to sentence you, as previously stated, to 1 year in the Bexar County Jail under 1244, giving you credit for any time served. There's a $0 fine. The court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, I
and
did.
sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. Do you understand?
Yes, Your Honor.
And I'm sure the Cadillac was not worth your time in custody.
It was not, Your Honor.
Yeah.
But it gave me a lot of time to get my mind right.
All right. I tell you, that's a bold move to write a check for over $12,000 and knowing it's not in the bank, but to still write it without your hand trembling. So don't do this anymore. It's not worth it.
Yes, Your Honor.
All right. Good luck to you.
Thank you.
You're welcome.
Have a seat, sir.
Maybe excuse me.
Yes.
Thank you, Judge.
All right. Who's next?
Lionel Young, page 2, 5 down.
Lionel Young. Sounds like they're willing to accept him in felony drug court as long as these cases are taken care of.
Judge, it was my understanding that he was rejected from the program.
No, he's rejected because he has 2 pending cases. Please re-refer once pending cases are resolved and granted probation.
Thank you, Judge.
Sure.
Judge, I was already planning on asking to have Mr. Young recalled for Thursday.
For what purpose?
Just to go over the options between the offer that's been given to him versus the potential consequences of a trial or the potential outcomes of a trial. And now that this has been brought to my attention, I also want to be able to gather some information and be able to explain this properly to him as well.
All right. Norma, recall this August 6th. All right, thank you.
Thank you, Judge.
And that will be your plea deadline date.
Yes, Judge. Thank you.
Thank you.
And then, Judge, does it happen to say which two, is this one of the cases that it's referring to as pending?
I'm sure it is. And then he has some cases that are,
Because he has a misdemeanor that was dismissed and then a less than a gram that was rejected. So as
Yeah.
far as I know,
probably it's just this one now.
okay, so what does it mean by disposing, like, put him on deferred to
He
do
either
the
has to be on
drug court?
probation.
Okay,
Yes.
gotcha, okay.
Before they'll accept him.
Thank you. Would it be, if I reach out to them, are they gonna tell me the terms or is that up to the state or? how
Oh,
does that
no,
work
what
with the
ends
drug
up
court?
happening is if you all agree to probation, I'll review everything. If I don't reject your plea and grant his application, then he will be transferred to felony drug court and felony drug court will set his conditions.
Gotcha. Thank you, Judge.
All right, thank you. And why is he in red? Is he a gang member or no?
Not to my knowledge, Judge.
All right, so if you're not a gang member, then there should not be any problems. Okay? All right, thank you.